Hello guys, this is Samuel Odhiambo Tieno, who is a senior law student at JQuat Current Campus. I'm welcoming you again to join me in SAMUELAW podcast and Academy YouTube practice so that together we can learn more about law. Today we are going to concentrate on contract law. Welcome. So we are going to start by defining what a contract is. A contract is a legally binding or enforceable agreement made between two or more parties. It may also be defined as a promise or sets of promises for the breach of which the law provides a remedy or the performance of which the law in some way recognizes as an obligation or duty. So how can a contract be created? To be legally enforceable, a contract must contain all the following elements or conditions. 1. There must be an offer and acceptance. 2. Certainty of terms. 3. Consideration. 4. An intention to create legal relations. 5. Capacity of the parties. And 6. Legality of purpose. So let's begin by looking at offer and acceptance. As already mentioned above, for a contract to come into existence, an offer has to be made by one party, who is known as the offerer, and accepted by another party, known as the offeree. An offer is a tentative promise made by the offerer, subject to a condition or request to the offeree. Immediately the offeree accepts the offer by agreeing to its requests or conditions, it now becomes a contract. The promise is no longer tentative, since the offerer is now bound to carry out his or her promise, while the offeree is also bound to carry out the condition or request. Acceptance must be made in some positive form, and it must be communicated to the offerer by the offeree. And once this is done, each party then becomes bound to the terms of the contract. Certainty of terms. The formation of a contract requires a meeting of the minds, otherwise known as consensus, of the parties as to the terms of the proposed contract. Both parties must have a clear understanding of their rights and duties in the transaction for there to be consensus. This therefore requires that the terms of the proposed contract be reasonably specific, or alternatively be reasonably ascertainable by means of an agreed formula or principle of determination. An agreement to agree on certain terms later on is definitely not a contract. Consideration. At the root of a contract is the concept of a bargain, that one party must pay a price, that is, make some contribution for the promise he or she obtains from the other party. For the most part, consideration is essential to make a contract binding in law. An intention to create legal relations. For an agreement to be enforceable, it must be deliberate or seriously intended, so that it is understood that in the event of a breach of its obligations, the parties could enforce the contract through courts. In business transactions, it is presumed that parties do intend the agreement to have legal consequences, unlike in government, where such is not always the case. Capacity of parties. The law presumes that each party to the contract has the legal capacity to enter into it. This is because an otherwise valid contract may be defeated by lack of a contractual capacity of one of the contracting parties. Legality of purpose. The object of the contract must be legal. Business transactions must neither offend the public good nor violate the law, because if they do, the contract will be deemed to be void, which in law simply means that it was never formed. All these mentioned above are the constituents or ingredients of a contract which make it legally enforceable or render it totally invalid. Let's now look at the types of contracts. Contracts may be classified as 1. We have written or specialty contracts. These are those contracts which under the law must be written, that is, embodied in a formal document. And the examples include hire purchase agreement, sale of land contract, and many others. Number 2, we have contracts under seal. This is a contract drawn by one party, sealed, and then sent to the other party or parties for their signature. Such contracts requires no consideration, that is, an act or promise offered by one party and accepted by the other party as a price for that other's promise. And examples include lease agreements and even mortgages. Number 3, contracts requiring written evidence. These are contracts which must be evidenced by some notes or memo containing a description of the subject matter, the consideration which is the value, signatures and descriptions of the parties sufficient to identify them. Examples here include contracts of insurance and contracts of guarantee. Then number 4, we have simple contracts. These are contracts whose formation is not subject to any legal formalities. The contract may be oral, written, partly oral and written, or simply implied from the conduct of the parties. And they include contract of sale of goods, partnership agreements, and even construction contracts. Conclusion. A contract comes into existence when an offer made by one party, who is the offerer, is unequivocally accepted by another, who is the offeree, and both parties must have the requisite capacity. Some consideration must pass, and the parties must have intended their dealings to give rise to a legally binding agreement. The purpose of the agreement must be legal, and any necessary formalities must have been complied with. Let's have a recap of what we've just learned. So in this module, we've been able to learn the meaning of contract law. We've also been able to define and understand the different elements of a contract. And finally, we've also learned about the different types of contracts and their formations. I thank you very much for watching. See you in our next module, where we shall try to analyze contract law further by looking at all its elements one by one. Welcome. Do you have any questions or comments? Kindly post them in the comment section below the video. Otherwise, thanks for watching this video. Please remember to subscribe to my YouTube channel, like the video, click the notification bell, and share with your friends and family or networks. Thank you.